it's a yes or it's a no. Are you of good character? Please don't answer this question. But which person would say this? I mean, it would be a very audacious person who would say, I'm honest, Ameen, and everything. And then probably he will be making other claims which will be totally not permissible. So simple validation is a bitter pill which has been swallowed from time to time to get democracy back on the rails. Would you not agree with that, since we consider you a constitutional expert, to consider validation at par with a constitutional provision, or it has to be read in the context of, because this judgment also says in space and time. The space then was a dictatorship. Either you continue another 10 years of a dictator or get some sort of a diluted form of democracy, get us back on the rails, whichever is better. So probably the parliamentarians, we should not always condemn the parliamentarians. We should see the difficult circumstances that they work under. I mean, we should respect them. And what would you have done? Let's put yourself in the position of parliament, make yourself a parliamentarian then, that you would, validate something which you may not be very happy with, but at least get the business back on track. How would you personally attend to it?
My Lord, my respectful submission is that though the earlier two judgments which I have just identified by this Honorable Court do not put it in the terms that your Lordship has, but that was probably at the back of their mind when they said that an amendment made during the period of constitutional abeyance, if it is in conflict with or cannot be reconciled with the provision originally enacted in the Constitution, then the latter will prevail. So obviously this Honorable Court has not treated the validation at the same level as the original Constitution, recognizing all the difficulties which your Lordship have articulated, but not articulating them in this particular manner. Otherwise, my Lord, if any amendment made to the Constitution, eventually when made, stands on the same plane as any other constitutional provision, but your Lordships have held that we will distinguish between constitutional provisions made during a period of constitutional abeyance.
What's your main argument? Is this your mainstay of your argument?
My Lord, my main argument in this particular case would be that insofar as when your Lordship examines Article 62 and 63, because some of these amendments, as your Lordship has just now noticed, came in at the same time, there is a relationship between the two. And with great respect to this extent that Samiullah Baloch says that 62 and 63 have to be looked at through different lenses, it is, with great respect, incorrectly decided. Because when your Lordship looks at 62 and 63, and the amendments came about at the same time, 62F, which your Lordship is looking in particular, which says he's sagacious, righteous, non-profligate, honest, and Ameen, there being no declaration to the contrary by a court of law, and your Lordship examines it with 63(1)H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. They are to be read together.
I mean, that is dependent upon 62 is dependent upon 63.
63, and I would go to the extent of saying that when your Lordship looks at G, for instance, he has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan. It has to be related to H, which says he has been on conviction for any offence involving moral.
So what does that mean? I mean, where does that leave these provisions 62?
My Lord,
what's the effect?
My submission would be that unless there is a conviction, and that would be the declaration I would be seeing, not at...
So what are these clauses? They go?
My Lord, if there is no conviction, then in the case of
D, E and G, for example.
My Lord, D and E and F probably all will have to be related to H. 63(1)(h.
F actually talks about a declaration, D, E and G don't. They could be, one could argue that because there is no third party declaration, we can go into conviction area. But where do we take the declaration part?
My lord, declaration, now if your lordship looks at it in terms of section, one thing which immediately comes to mind is section 42 of the Specific Relief Act,
yes,
which talks about declaration of a legal character. Now, this cannot be that kind of a declaration because, as your lordships have repeatedly observed, a negative declaration is impossible to obtain. Then your lordship,
sometimes permissible, negative declaration is permissible sometimes in some events that
Yes.
can be granted by
Yes.
the court.
there has been some
totally bar of
revisitation
negative
or
declaration.
some revisitation of Alvi Sons, but otherwise that remains good law. Then if your lordship looks at 199, that also is talking of declarations being made by this honorable court, but that's in a completely different context.
That is only
Then what do you make out of this declaration for a court of law?
My lord, I would say that the term is not used specifically in the section 42 sense of the term.
Maybe it's a constitutional declaration.
It's a constitutional declaration, and that the declaration which the Constitution is envisaging is there has been a conviction already under 63(1)(h). And then there is this gateway. He cannot file his papers before the returning officer because at that time the returning officer may refuse to accept them. But the anomaly which arises when your lordship looks at 63(1)(h) in particular, and G and H both, actually, when your lordship looks at it, for instance at H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. So even a conviction which is followed by a sentence of 1 year 11 months does not lead to disqualification even of 1 day.
Enough. So that's understood.
So therefore the connection which Samiullah Baloch makes between a person being an ex-convict suffering all his life, the stigma that he's a convict, is really not what 63(1)(h) is all about. 63(1)(h) is all about sentencing. If the person has been convicted and sentenced till the rising of the court, he's not disqualified at all.
No, but there is a difference, you see, the opening paragraph of section 62 and 63.
My lord,
They need to be read
Yes.
and harmonized. A person shall not be qualified to be elected or chosen. I mean, if you will read 63, a person shall be disqualified from being elected or chosen. So वो जो उसमें चीजें लिखी हैं वो आफ्टर कन्विक्शन है कि अगर कोई कन्विक्ट हो गया है, उसकी सजा खत्म हो गई है, तो इस इतने पीरियड के बाद वो इलेक्शन लड़ सकता है. To be elected and from being elected. This is the
Correct. But if your lordship may graciously be pleased to look at clause 2 of 62, these words are used very loosely. The disqualifications specified in paragraph D and E doesn't talk about qualifications. Article 62,
but both are dealing
Clause two.
different situations.
no, my lord, Article 62, clause 2 is talking of disqualifications under 62. It's not talking of qualifications. So this is very loose language which has been used.
Practically interchangeable.
Interchangeable language. Because
One question which I
My lord.
have, DE
My lord.
does not have the wording, there being no declaration to the contrary by a court of law.
My lord, yes.
When does DE
वापस आएंगे इस ब्रेक के बाद.